Good afternoon. I am so delighted to see you all today, and I am delighted to welcome our guest to the first of our endowed lectures of the year. Before I introduce today's event, I want to just take a brief moment to recognize the passing of a true icon in Indiana. An incredible friend to this law school, and obviously to our friends at the McKinney School of Law. As you may have seen, Bob McKinney passed away over the weekend at the age of 98, leaving behind an extraordinary impact on the Indiana legal profession and well beyond. And we look forward in the near future to honoring Bob's life and legacy in a more robust fashion. But I just wanted to recognize his passing while we're all together right now. With that said, today also marks the 78th year of the Harris Lecture Series, which was established in 1946 through a trust from the request of India Crago Harris in honor of her husband, Addison Harris. Addison was a Wayne County, Indiana native and a former professor and president of the law school from 1899 to 1904. Addison Harris was a distinguished statesman. He was a member of the Indiana State Senate and served as a minister to Austria-Hungary under the administration of President William McKinley. After Addison's death, his widow India endowed this lecture series in his honor to instruct lawyers and students of the law in the higher and more advanced questions and theories thereof. Past Harris lecturers have included some of the most well-known attorneys and legal scholars of our generation. They are people who have changed the way we think and have had a tremendous impact on the law and on our legal institutions. Past Harris lecturers have included Judith Resnick, Martha Minow, Cass Sunstein, and civil rights icon Julian Bond, among many others. This past January, we were honored to have Professor Danielle Citron with us to deliver the Harris Lecture, and today we are thrilled to have Yale Law Professor Keith Whittington, and Steve Sanders will be making a more robust introduction. Thank you.
Thank you. I want to welcome not just students and faculty and staff from the law school, but also colleagues from around the university. And we had, as of last night, 150 people signed up by Zoom. This is also live by Zoom for people both in Bloomington and elsewhere who couldn't make it, so we're delighted to welcome them as well. Keith Whittington has been for many years a prolific and much admired scholar of both constitutional theory and interpretation. Not long ago, he told an interviewer that he mostly took free speech for granted throughout his career, even though, as a conservative in academia, he knew he would have to, as he said, carefully navigate an environment that was politically sometimes fairly hostile. But Professor Whittington soon found that taking such freedom in the academy for granted was almost impossible, as attacks on principles of free speech and the related principles of academic freedom ramped up from both the political left and the political right. And so he turned his intellectual energies to the problem. As a result, he has become, I would argue, the foremost scholar today working on questions surrounding professorial speech and the relationship between academic freedom and the Constitution. In his 2018 book, Speak Freely, Why Universities Must Defend Free Speech, Professor Whittington argued that universities must protect freedom of speech because it goes to the heart of their missions to project and foster freedom of thought, ideological diversity, and tolerance. And in another book published just earlier this year, You Can't Teach That, The Battle Over University Classrooms, he warns that the battle for control of the university classroom is now brewing, and the courts will be called upon, inevitably, to establish guidelines on what limits legislatures may have in dictating what is taught at public universities. Keith Whittington earned his bachelor's degree from the University of Texas and his PhD in political science from Yale. He taught for many years at Princeton, where he was the William Nelson Cromwell Professor of Politics, before taking up his current appointment as the David Boies Professor of Law at Yale Law School. His scholarly output has been prodigious, but he's equally skilled at communicating to more general audiences through op-ed essays, blogging, and podcasts. And finally, in 2021, Keith and several colleagues founded the Academic Freedom Alliance, which has quickly established itself as the leading independent, nonpartisan, non-political watchdog organization advocating for faculty members whose academic freedom is threatened either by their own universities or by outside forces. So please join me in welcoming Keith Whittington for what I understand is his first visit to IU Bloomington. So.
Well, thank you very much. I appreciate y'all coming out. I appreciate the opportunity to come visit. I am pretty certain this is my first visit to Bloomington, although it did just now occur to me, although it should have occurred to me before, that my brother-in-law is actually an alum of this fine institution, not this fine institution of the law school, but of the undergraduate college here as well. So I'm glad for the opportunity to come and to participate in what is really a quite remarkable lecture series. I had not realized the number of luminaries who had spoken in this over the course of decades, and so I will try not to drag down the standards too much, but no promises. And it's I really appreciate the opportunity to come to talk about this particular topic. So I want to focus on a specific kind of issue relating to academic freedom that has arisen here in Indiana, which is the passage of Senate Bill 202, focusing on creating what's been characterized as intellectual diversity mandates for professors teaching in public universities in the state. This is a quite unusual piece of legislation, although this kind of idea had been talked about for quite some time. We're seeing a lot of legislative and policymaking activity around universities and university teaching all across the country, but this particular bill is distinctive from what's been done elsewhere. And so this is an opportunity to try to explore what are some of the challenges associated, I think, with this piece of legislation, and to the extent to which it becomes a model for potential policy to be made elsewhere, as well as something you'll have to figure out how to live with here in Indiana. I think it's worth thinking very carefully about what the challenges are going to be, and what the real problems are, and what kinds of things might not be problems under this kind of legislation as it's at least laid out. Lots of implementation challenges to come, as we'll talk about. And I also want to make sure that I leave time to hear what's on your mind with questions on this, and so I will try to make sure that I don't talk too long, but I want to make sure I set the table reasonably and put some of the important issues on the table, at least to talk about. So as you may know, Senate Bill 202 was passed into law in the spring of 2024, so we're now in the process of trying to develop implementation standards for how this law is going to play out in practice in state universities in the state of Indiana. This was sponsored by Senator Spencer Deary, who is relatively new to the state legislature, but somewhat interesting feature of the senator is that he's former deputy chief of staff to President Mitch Daniels at Purdue. So he has a fair amount of experience in higher education and thinking about the issues associated with higher education. And moreover, former Governor Daniels, as the president of Purdue, was very concerned with free speech issues there on that campus and trying to think about how to advance these kinds of concerns of free speech and academic freedom there at Purdue. So interesting to have a member of his staff now proposing legislation of this sort. There is a broader context, though, that we should be bearing in mind as we think about the specifics of this bill. And moreover, this bill actually borrows a little bit from some of that larger context. And mostly I'll just mention them, but then set them aside. Happy to come back to them. But they're probably not the more interesting features, I think, of the law as it was passed. But we've seen, as I mentioned, proposals to make policies, sometimes at the legislative level. We've seen a little bit of movement at the gubernatorial level, so there have been some sort of action by state attorney generals and by governors through executive action to try to regulate universities, and moreover, there's been some activity at the level of Board of Trustees and regents for universities trying to make related policies affecting how universities operate over the last few years. The most high profile and I think controversial of these kinds of measures are so-called anti-critical race theory bills and proposals, sometimes called anti-divisive concepts proposals that have been moved through state legislatures to varying degrees. The first and most prominent version of this was the so-called Stop Woke Act passed by the Florida legislature and is now currently being enjoined by federal courts down in Florida. As it's making its way through litigation, we'll see where that ultimately lands. Thinking through some of the challenges of those anti-critical race theory bills, which are designed precisely to prohibit professors from advocating certain ideas in the classroom in state universities, is central to part of what I try to do in the book that just came out, the You Can't Teach That book. This piece of legislation, on the other hand, does not try to take that same approach. It does not ban certain ideas from being talked about in the classroom. It, unlike some proposals that have been floating in various legislatures, again, with varying degrees of success, it doesn't attempt to abolish tenure for academics. As some others do, but it does leverage the tenure system to try to impose a set of new restrictions on how classes get taught within state universities. But before I get to the sort of two more interesting features of the legislation, it's worth at least noting that this is a pretty broad package of specific proposals that were part of this Senate bill, and a lot of its features are actually more familiar from things that have happened in other states as well, and so don't put on the table some of the unique kinds of challenges, I think, that are more distinctive to this particular bill. But among those is, for example, the expansion of diversity programming in state universities to include intellectual diversity. So unlike some states where there's been a real move to try to gut or prohibit various kinds of diversity programming on college campuses, here the goal is instead to expand out the kind of diversity programming that takes place to include so-called intellectual diversity along with other forms of diversity that might be incorporated into college programming. Secondly, there are some provisions in the legislation designed to protect faculty free expression to a somewhat greater degree than might already be true under state law, although probably does not make a significant change as to what kind of protections already were in place under campus policies. Third, it bans the use of diversity, equity, and inclusion statements or diversity statements for applications in either faculty hiring or for student admissions in state universities. We've seen quite a few states moving in this direction through their own policies and laws. And we've seen quite a few private universities abandoning these kinds of requirements that they had themselves adopted over time. And so this is in keeping with what we've seen in some other places. Fourth, it requires state universities to adopt a policy of so-called institutional neutrality, which is, although somewhat controversial on the margins of how it applies, but this is most associated with the University of Chicago, which has long been committed to the view that the university should not itself as an institution and its university leaders, like the university president, for example, should not stake out positions on contested social and political issues of the day. And so universities ought to be places where individual members of the faculty, individual members of the student body can debate and discuss political political issues, but you shouldn't have university presidents making their own declarations as to what they think the right view of the war in Ukraine or the like might be. And then finally, it requires some student intellectual climate surveys to be conducted on state university campuses. And again, we see this being a feature of policies that have been adopted in quite a few other places as well. But more interestingly, there are two components to this bill that are quite unique to this particular legislative effort. And it wouldn't surprise me if other states are inclined to at least look closely at this proposal and consider passing it as part of what they're doing in other states as well. These intellectual diversity mandate features of the bill do at least borrow a little bit, at least conceptually, from things that have been talked about a decade or more ago, but never actually went very far in legislative circles, but were talked about among conservative activist groups, encouraging legislatures and universities to incorporate more of what they characterize as intellectual diversity into classroom teachings and other ways. So that set of proposals that have been advocated for a while sort of faded out and was not getting very much attention more recently. And this bill, I think, is going to push that back into the limelight, and we're going to find ourselves debating a set of policy proposals that were not high on the agenda before, but are likely now, I think, to get a second look in not only probably state legislatures, but moreover, if Republicans are actually successful in capturing both Congress and the White House, it wouldn't surprise me if we wind up with some real close looks at these kinds of measures for purposes of federal legislation or Department of Education policy making and rulemaking relative to universities as well. So what are the interesting, unique features to Senate Bill 202? So as I said, the sort of most of the attention is focused on sort of one of those two components, focusing on so-called intellectual diversity mandates. But they're both designed to advance and protect what the legislation refers to as free inquiry, free expression, intellectual diversity on college campuses. And it does so through two separate components that are both worth taking into account because they both, I think, are going to matter a lot in terms of implementation and consequences for what this policy looks like. One is simply thinking about the enforcement mechanisms that are being used to try to advance this goal of inculcating more free inquiry and intellectual diversity in campuses. And the primary enforcement mechanism comes through the control of faculty hiring and promotion, and in particular, tenure. Although, interestingly, the bill does make reference to non-tenure track faculty as well. But most of the meat of the legislation is focused on the tenure process. So faculty are highly aware of how the tenure process works. But for others who are blissfully unaware of the details of tenure process, you should be, so when faculty are hired on a long-term basis to universities in the United States, the normal mechanism is that they are given a set of short-term contracts on which they are in a kind of probationary status before they come up for review on whether or not to be offered a long-term contract with so-called tenure protections. And the norm in America for most of these, for this probationary status is in the ballpark of 5 to 7 years, although it varies by institution as to quite how long that process might be. And it's sort of an up or out system. You either then get promoted to the tenured ranks at that stage, or you are allowed to go elsewhere and pursue your career someplace else. I thought of it as an opportunity to be fired. But, you know, and so this moment of whether or not you're going to successfully cross this threshold and get tenure is a critically important moment for the careers of faculty at an extraordinarily high pressure decision, both for the faculty member who's trying to accomplish this, but also for the institution that's trying to make decisions about what kind of long-term investment are we going to make with this person, because once we've given them tenure, very hard to remove them in the long road. So So it's a very consequential decision more generally. And universities have, or states, I should say, across the country, especially in more conservative leaning states, and primarily relative to state universities, this has been much less true for private universities, has been chipping away at those scope of tenure protections more generally. Now, there's one big way in which they've been chipping away at it, which is simply not put people on that tenure track in the first place. And so we've seen over the course of the last several years a massive increase in the number of so-called contingent faculty who are never on this track of potentially getting tenure. They're hired on often one-year contracts or class-by-class contracts or semester-by-semester contracts with no particular promise that they will ever be considered for long-term employment. So we have a whole set of faculty who operate outside that tenure context, but even within the tenure context, what we see in a lot of universities adopting increasingly robust versions of what are called post-tenure review. So that after you've been rewarded tenure, you periodically come up for renewal of your tenure and a more substantive evaluation of whether or not you should continue to be employed over time. And the enforcement mechanisms associated with Senate Bill 202 try to leverage both that initial tenure decision, but also the post-tenure review system. So even after you get tenure, you're still going to have this requirement for intellectual diversity hanging over your head because it will feature as part of the periodic post-tenure review process as well as whether or not you get to keep your tenure and keep sticking around. And so instead of, unlike some bills proposed in some places, this bill is not designed to strip people of tenure per se. It's not designed to, I think, gut the tenure process per se, but instead to leverage the tenure process by saying we're going to continue to allow you to have this great privilege of tenure, but we're going to use this mechanism as our big enforcement tool for encouraging faculty to behave differently in how they conduct their professional duties so they orient themselves toward doing what the state legislature wants them to do. And notably, this is going to, this system of trying to think about how tenure can be used to affect what people are doing in the classroom and evaluate how people are behaving in the classroom will also be driven through two specific mechanisms. One, through the Board of Trustees. So at the end of the process by which people are granted tenure at universities, you go through a process in which there are votes by your departmental colleagues, then deans sign off and presidents sign off and tons of other people sign off. And then eventually the Board of Trustees signs off, and they're the final legal authority with the actual legal authority to then grant people those kinds of long-term contracts. So at the final stage of the process by which faculty are being hired and evaluated, they have to get approval of the Board of Trustees to move forward. Now, usually that's a rubber stamp. The Board of Trustees, generally speaking, have deferred to the faculty and to the academic components of the university to make these core decisions. And so at the end of the day, a slate of people come up to the Board of Trustees for a meeting in which say, the president has agreed and faculty have signed off on all these people getting tenure. And then the Board of Trustees says, great, and let's move on to talk about important stuff like the football program. What this legislation does, though, is say the Board of Trustees can't keep doing that. The Board of Trustees has to be more interventionist, more activist, and substantively reviewing the people who are coming up for tenure and certifying that they have met these specific legislatively imposed requirements before they are to be granted tenure. So it brings the Board of Trustees much more actively into the process of evaluating faculty and not just rubber stamping whether or not they should continue to be employed. And so that opens a big question about, well, how will the Board of Trustees actually behave in practice, given this new authority and really a directive as to how to conduct themselves. And part of the reason why Board of Trustees have, over the course of the 20th century, through a long struggle between faculty and universities to create this situation, the reason why Board of Trustees have largely deferred to the faculty and to the academic side of the university on these decisions is precisely on the claim that boards of trustees are not well situated to actually make reasonable decisions about the quality of faculty hiring. And so the assumption for the faculty, at least, is that the quality of the faculty that you're employing in the university and whether or not to give them tenure and retain them in the long term is ultimately a set of decisions that requires expert judgment about their scholarly credentials and scholarly activity and productivity. And that's something that's best done by the faculty itself. And as a consequence, the board trustees are not well positioned to second guess the faculty as to whether or not this physics professor that the physics department says is doing excellent work and we ought to keep him around for the long term. The board trustees has no idea whether or not that physics professor is actually doing any excellent work or not, and whether or not we really ought to keep them around long term. And so the board trustees have backed away from having to make those decisions and just said, well, the physics department thinks they're good enough for them, we'll assume that's true. So the Indiana legislature has now really insisted, no, you have to get in there and make some substantive decisions, at least on some specific grounds, in thinking about this. And so that's going to open a very interesting experiment as to how this goes, with board trustees becoming more active in trying to assess faculty employment. The other mechanism is a little different. So not only do you have this routine option of the board trustees becoming involved in the tenuring decision of faculty, and then also these post-tenure review decisions for faculty. But then there's also a more ad hoc and intermittent process by which students can complain to new administrative offices that the law requires be set up in state universities to be staffed, as the legislation says, by human resource professionals and supervisors to assess complaints from students about whether or not faculty are actually living up to the requirements of the legislation. So if students are unhappy with what faculty are doing in the classroom, they can then file an official complaint with these new offices. Human resource professionals are now in charge of assessing whether or not these complaints are reasonable and triggering a process that could potentially lead to faculty members being stripped of tenure and fired as a consequence of those student complaints. So you have a routine, regularized process by which the board trustees are going to be overseeing this, and then you have this more ad hoc process by which students and others might file complaints, and some new agency in the university is going to assess faculty. So what's the substantive standards by which they're supposed to be assessing faculty in order to establish our new utopia of a university dedicated to free inquiry, free expression, and intellectual diversity? So the law sets up three core standards of concern and says that faculty should be dismissed from the university. Individual professors should be dismissed from faculty if any of these three standards are met. So one, is this faculty member unlikely to foster a culture of free inquiry, free expression, and intellectual diversity? So one, are you unlikely to foster a culture of free inquiry? Secondly, and I think that substantively is important. It's been largely overlooked, and I'll come back to that in a minute and try to unpack what might this actually mean in practice. Secondly, and this is the thing that's gotten most attention, the so-called intellectual diversity mandate, is the faculty member unlikely to expose students to scholarly works from a variety of political or ideological frameworks that may exist within and are applicable to the faculty member's academic discipline? Right, so this is the so-called intellectual diversity mandate. Is the faculty member unlikely to expose students to scholarly works from a variety of political and ideological frameworks that may exist within the academic discipline? And again, I'll come back to that in a minute as well. So then third, is the faculty member likely, while performing their teaching duties, to subject students to political or ideological views and opinions that are unrelated to the faculty member's academic discipline or assigned course of instruction? If the faculty member fails on any of these three standards, and we know that either through this routinized process of Board of Trustee review of their promotions, or through this ad hoc process of students complaining to human resource officers about faculty conduct, then the professor in question ought to be removed from the faculty. So what are the problems and potential concerns about how this is going to play out, and why should we worry about these things? So I think that the third standard that I just suggested, this, are they likely while performing their teaching duties subject students to political or ideological views that are unrelated to faculty members' academic discipline or assigned course of instruction? This standard is actually totally consistent with existing professional conduct expectations for faculty. That is to say, faculty members who engage in this behavior right now under existing rules, not only at Indiana, but also at most universities across the country, should already be subject to discipline. Now, in practice, they rarely are disciplined for this kind of conduct and behavior. But as a matter of policy and principle, faculty members who subject students to political views and opinions that are unrelated to the course are misbehaving. They're taking advantage of their captive audience to engage in discussions that do not advance the educational purposes by which the students are in that classroom in the first place. Academic freedom advocates from the very earliest days of the American Association of University Professors, which first laid out academic freedom principles in the United States in the early 20th century, have long held that faculty do not have the right to engage in that kind of behavior in the classroom. So to the extent that this has now been made legislative, it's going to create more teeth for this requirement. It's going to create new enforcement mechanisms. Like I said, the Board of Trustees may not be the best people to be making these assessments particularly. But in terms of the standard of conduct that's required of faculty, at least we know what we're getting here. This is a standard of conduct that's already fairly well developed within our expectations about how faculty look. You can see lots of policy guidance about what that ought to look like already. And so there's nothing terribly surprising about this particular expectation. As a consequence, I'm much less concerned about this one. The other two, though, I think are really worth unpacking and trying to think about how they're going to play out more specifically, including this first one, which sounds very nice and therefore not so problematic. And as a consequence, I think is mostly flown under the radar. That is the standard of, are you unlikely to foster a culture of free inquiry, free expression, and intellectual diversity? So I think there are some ways that might be interpreted and applied that probably simply, again, reinforce existing expectations for the faculty and how they conduct themselves more generally. But the real question is, what is a Board of Trustees likely in practice to think constitutes activities by a faculty member that is inconsistent with fostering a culture of free inquiry and intellectual diversity on a college campus? Well, among the things we might imagine faculty members doing that I think is inconsistent with current expectations about how they ought to behave, and as a consequence, this law would just add some enforcement teeth to existing professional expectations, is, for example, faculty members who engage in campus disruptions. So if faculty members themselves, for example, participated in shouting down a speaker on campus, they themselves then would, I think quite reasonably, not only would they violate probably other existing policies that exist on most university campuses that prohibit you from shouting down speakers, whether you're a faculty member, a student, or anyone else, but in addition, I think quite reasonably would be viewed as acting in a way that is inconsistent with and hostile to maintaining a free inquiry culture on the campus more generally. And so faculty who engaged in those kinds of disruptive activities on campus in order to prevent other people from engaging in their intellectual work on the campus are likely to run afoul of this statutory requirement and as a consequence have a new set of enforcement mechanisms to worry about. Secondly, and I think much more subtly and much trickier than to identify when it's occurring, is there is a possibility of faculty members shirking administrative work and shirking their duties in a context in which they are being motivated by political hostility to actions that are being undertaken by others. So to give you an example of what this might look like in practice. So imagine a faculty member is asked by imagine a faculty member has relevant expertise relative to a graduate student in a department who is embarking on doctoral work, and as a consequence, because they're embarking on doctoral work, need to put together a dissertation committee. And in most universities, for most departments, a dissertation committee consists of 3 advisors, sometimes more, who are going to supervise the independent research project that will lead to the PhD and allow a graduate student eventually to move on to hopefully get a faculty position and the like. That process by which you assemble that committee of dissertation advisors usually is simply a matter of students going to faculty and asking if they'd be willing to participate in their particular committee and then agreeing to supervise that activity over time, and faculty members saying yes or no. So there's no, generally speaking, individual obligation on the part of a particular faculty member to agree to sit on any particular student's dissertation committee. And faculty say no for all kinds of reasons relative to sitting on dissertation committees. I don't really have the right expertise. I'm already swamped with too many things. I can't do your particular thing. But you also have some less admirable reasons why faculty sometimes decline to serve on dissertation committees. So for example, I can't stand to be in the same room as the person who's going to be your dissertation committee chair. And so I couldn't possibly be on your dissertation committee because I can't stand that person who's also on your dissertation committee, and so we can't work together in an effective way. And that's a real story. People really do behave in this fashion and somehow keep their jobs. So we have that kind of reason, not a good reason, but nonetheless it sometimes happens. But you can also imagine a faculty member saying, tell me more about this dissertation project you want to work on. The student describes it and says, I just really disagree with the politics behind that dissertation. I disagree with the ideas that you're advancing and expressing, and so I don't want to work with you. Not because I think it's illegitimate academic work, not because it's outside my expertise, but because I substantively disagree with your views such that I would prefer you not actually successfully make your way through the program and get a dissertation, and I will do my little bit to hinder your ability to get your PhD by refusing to serve on your dissertation committee, for example. I think that kind of behavior would probably also run afoul of this legislative requirement and could get a faculty member then in hot water under this requirement. I think there's other more subtle things that faculty members could be doing of that sort that could become problematic in ways they're problematic under the law, but also problematic already under existing standards of professional conduct for faculty more generally. And then finally, the final example of things where I think the law is just going to give teeth to something that's already true about our expectations of faculty conduct is concerns about classroom indoctrination. If I'm using my classroom to indoctrinate students in particular views in the classes, that's already viewed as outside the scope of academic freedom protections, more generally inappropriate for faculty to be doing, something that can get you in trouble from university administrators for engaging in and the like. And I think also could then be read as inconsistent with this new requirement that faculty behave in ways that preserve free inquiry and intellectual diversity on college campuses more generally. Now, the challenge of dealing with classroom indoctrination is no one agrees about what counts as classroom indoctrination. And so for the last 100 years, faculty have said, you don't have the right to indoctrinate students. Universities have asserted that as well. It's outside the bounds, but there's very little agreement as to what actually counts as indoctrination in practice. In the article from which this is going to be developed, I'm going to try in part to unpack this idea, try to talk about some as well in the book, but just worth noting that accusations that faculty members are engaged in indoctrinating activity in their classrooms is likely now to fall under the scope of this particular legislative requirement, and as a consequence, trigger this particular set of enforcement mechanisms. So let me just briefly then run through as well then some areas where I think the law may impose new obligations that don't already exist under expectations about faculty conduct that are actually somewhat troubling for how academic freedom ought to work on college campuses. So one kind of concern is this requirement might be used to restrict some forms of scholarship. So for example, given this legislative requirement that faculty members, in order to retain their jobs, have to help preserve a culture of intellectual diversity and free inquiry, can I hire somebody to a public university in Indiana whose scholarly work is itself dedicated to challenging the value of free inquiry? And there are plenty of scholars who are engaged in that project and have been over the last several decades. So just to take a classic example of this is Herbert Marcuse from the 1960s, who was a Marxist philosopher, very prominent in the 1960s, remains extraordinarily influential. And part of what his core scholarly work was dedicated to, and part of what he remains highly influential for, is challenging whether or not free inquiry is even possible and under what conditions it's possible in capitalist systems more broadly, right? And that kind of scholarly agenda, intellectually extraordinarily interesting, as I said already, very influential within academia as a whole. But if you had a professor on your faculty on which that was their scholarly agenda, not clear that's totally consistent with the existing statute. You can totally imagine a board of trustees looking at somebody's scholarly agenda and the titles of their books, like Marcuse's Repressive Tolerance, for example, and just concluding that person seems to be engaging in activity that's inconsistent with this new legislative standard. And as a consequence, we've got to get rid of them. Right? So getting rid of people on the basis of you don't like their scholarly agenda because substantively it's unappealing is precisely what academic freedom is designed to protect in general, right? So you're going to potentially, as a consequence of this legislation, carve out some areas of scholarly inquiry and say we're not going to do those in the state of Indiana in our state universities. Secondly, there's potential concerns that may restrict some forms of intramural speech. That is to say, within the academic freedom literature, we sometimes distinguish between intramural speech and extramural speech, which is just to say speech inside the walls and outside the walls. And in particular, intramural speech is often thought of as speech as part of faculty governance. So what do I say in department meetings? For example, about hiring decisions for additional faculty. So imagine that I'm in a department meeting on a faculty in a state university in Indiana, and I say, you know, we shouldn't hire this critical theorist who's up for a job at our university because I think critical theory is mostly a lot of garbage, and we got way too much of it already, and so we need a lot less critical theory and a lot more something else, right? Can I now be sanctioned for that because I'm not supporting adequate intellectual diversity precisely because I've said now this area of scholarly inquiry is not very good and we need less of it in our college campus, right? This is a normal kind of thing to say, maybe a somewhat cleaned up, more sophisticated version than I just expressed it, but a not uncommon thing to say in faculty meetings, often not so cleaned up, and potentially saying that kind of thing in a faculty meeting could now get me fired. Under this kind of Indiana statute. Not me personally, because I'm at Yale, but you know, if you're here. So third, it could potentially restrict some forms of extramural speech. So extramural speech is outside the gates, right? So speech I engage in public about matters of public affairs more generally. So imagine that I'm on the faculty and I want to write an op-ed to the local newspaper complaining the university's gone too woke. And it has way too many people on the campus who are engaged in these woke literatures and scholarly agendas, and we need a lot less of that stuff on the college campus more generally. And now, am I now not supporting an adequate culture of free expression and free inquiry and intellectual diversity on my college campus because I've written a newspaper op-ed saying that whole swaths of my colleagues are engaged in garbage work and we ought to get rid of it and do a lot less of it? on our college campus. This is a normal kind of thing that we now engage in, of course, in our current political and policy debates surrounding higher education more generally. What kind of research should faculty be doing? Are they on the wrong path? Are they doing the wrong kind of stuff? If faculty members contribute to those kinds of public debates through op-eds and other public expressions, are they going to wind up running afoul of this kind of standard? And I think it's entirely possible they will. So let me turn then to the more prominent feature of the statute, and very briefly, because I've already talked too long, which is the intellectual diversity mandate itself, right? Now recall, this is the mandate that says, is the faculty member unlikely to expose students to scholarly works from a variety of political or ideological frameworks that may exist within and are applicable to the faculty member's academic discipline? Now note there's actually some nice things about this language that I think the public discourse surrounding the statute has tended to minimize. Still real questions about what the implementation looks like. But one thing that the statute is designed to do, at least in terms of statutory language, is to say we're concerned with political and ideological frameworks that exist within the relevant discipline already. So the question is not, if I'm a biologist, do I have to take seriously creation science as part of what I'm supposed to be teaching in my classroom? The claim is not, do I have to take seriously flat earth theory? It's not, do I have to take seriously claims that the earth, that the sun revolves around the earth rather than vice versa in my science classes, right? Because the concern with the statutory language, at least, is to say, you have to be concerned with a range of views that exist within your academic discipline. But just because people are saying it on YouTube does not mean you have to bring it into the classroom necessarily. It's not an equal time requirement for anyone who might disagree with anything that you might otherwise be presenting in the classroom. But that still leaves an awful lot of material out there, a lot of contestable arguments out there that would potentially have to be incorporated into your classrooms as a consequence of this intellectual diversity requirement. And then the question is, okay, what's that going to look like in practice, and what kind of problems might that create? Well, one very basic problem is the question of, what does it mean to say you're going to expose students to a variety of political and ideological frameworks? What counts as a variety? The legislation gives us no guidance at all. This does not tap into any kind of pre-existing professional standard, and so we don't have any kind of common law we can look to and say, well, there's a practice out there. We could identify what counts as a variety and what doesn't count as a variety. So imagine, for example, that I was tasked with teaching a survey course in history of Western philosophy. And we'll even make it easier and say pre-modern history of Western philosophy, because, you know, it's a lot to do in an entire year. And I offer in my class, we're going to do Plato, and we're going to do Aristotle, and then we're not going to have time for anybody else, sorry. Right? Well, I got all kinds of variety there. I got both Aristotle and I got the Plato. I don't have anyone else that normally people would have in such a survey class, but have I satisfied the variety requirement? Right? Don't know. On the other hand, if I have lots more readings, I have a ton of readings from all kinds of perspectives and ranges, when have I satisfied the variety requirement, and when have I crossed that threshold necessarily to know? And the answer is simply, the law doesn't tell us, and we have no good reason for knowing necessarily. And the answer probably is going to be, it depends on what the board of trustees thinks when it looks at your syllabus and decides, oh yeah, that looks like good variety to us. Or they look at your syllabus and say, that doesn't look like good enough variety to us, you should have done more. So imagine I'm not asked to teach the class in pre-modern political theory, but instead I've decided I'm going to offer a seminar on originalist constitutional theory interpretation. So I got a range of originalist scholars and a range of different views that they're offering. But, you know, there's other originalists that I'm not going to include on my syllabus. And, you know, I don't have time to talk about the critics. And so they're just off the table. You can get that someplace else. Have I offered a variety in that context? Do I have to include the critics in order to say I now have enough variety? Is it enough that I can say, well, look, I got several different flavors of originalism in my Con Interp seminar. And moreover, I may even have different flavors of politically salient originalists. So I have some liberal originalists, like my colleague Akil Amar and Jack Balkan. I have some libertarian originalists in there. I got some classic conservative originalists in there. And is that sufficient variety to satisfy the statutory requirement? Nobody knows. Nobody knows. Which means then this is going to be very open to very arbitrary enforcement by board trustees. So if I have some student who complains to say, I didn't like your seminar very much because you left off my favorite originalist or you left off my favorite critic to originalist, I now get to go to what the legislation requires a human resource professional and supervisor to explain to them how well designed was my originalist seminar after all, and did I include the right kind of people? Probably not a good way of running a university in general. And I would note that part of why that's not a good way, because not only is it problematic that I now have to make this explanation to a human resource professional, but fundamentally because that kind of variety, that kind of political variety, is not itself an educational or scholarly value per se. It depends very much on what the specifics of the class are, what we're trying to accomplish here in this particular class, and moreover, it depends on the professional judgment of the faculty member in charge of the class as to whether or not this is going to be useful or not useful. So I may make an assessment that says, I think the best way of trying to make the best use of the time available is to leave off the critics of originalism, because we're going to make more progress in really diving into the details of the internecine conflicts of the originalist if we just skip the whole problem with all the critics. There's good educational reasons and scholarly reasons to want to make that assessment as a particular class is designed. And so you don't necessarily need, I think, human resource professionals to be looking over your shoulder, or board trustee members looking over your shoulder and saying, you know, I don't like that judgment. I think, in fact, you should have included the critics. And moreover, I got some specific critics in mind that I think you probably should have included. And if you didn't include that critic, then you probably don't have enough variety in your class necessarily. It's going to be a massive challenge, I think, for the university to figure out how to manage that kind of uncertainty and to prevent that kind of arbitrariness. It's going to be a huge problem, I think, for individual faculty members then that are trying to navigate this situation while trying to worry about, have I done enough that I won't get fired as a consequence of the decisions I made. And we're in an unfortunate situation because of the nature of the implementation enforcement mechanism. It will not be adequate for me to, for example, go to my dean and say, here's my syllabus, is this going to be good enough? Right? Because the dean can't make that promise. The dean might say, looks okay to me. I can see the educational value in that. I can see the rationale why you did it. But ultimately, the question is going to be, what's the board of trustees going to think when it comes up for your post-tenure review? And the answer is the dean has no idea, right? And can't promise on behalf of the board of trustees that I've done a good enough job, right? So there's no security that I can be offered as a faculty member in this situation that I have done a good enough job going in. All I can do is guess about what the board of trustees might be doing down the road. And that's not a healthy situation for individual faculty. It's certainly not a healthy situation for, well, we might say, for the values of free inquiry and free expression on a college campus. So again, I apologize because I talked way too long, but we do have a little bit of time for questions.
One announcement I need to make, and it's important the Zoom audience hear this, is that if you're on Zoom and you're pursuing CLE, the code that you need is 45235. That's 45235. It's the code that just proves you watched all the way to the end on Zoom. So with that,
I like that you saved that to the end, because you don't want to give that away at the beginning, right? Yeah.
So I can let you call on people if you'd like, but I saw that very enthusiastic.
So my understanding is, because we're doing the Zoom thing, you need to speak to the microphone, because while I can hear you, they can't hear you. Or I could repeat the question. Well, there's also that possibility. Let me misinterpret your question, and so that'll be easier.
Thank you. Thank you for a great lecture. My question actually concerns the last bit. You talked about the second standard and the variety of intellectual frameworks. And as you were talking, I was thinking that the syllabus actually is a good mediator of this. And in fact, it's already been talked about in our department that you just need to be clear about what is in your syllabus. It's like a contract. It's like being transparent with teaching. You seem to suggest otherwise, but why isn't, as long as you make it clear, what is the scope of your course? And within that, isn't that a potential solution?
I hope that's a potential solution. Yeah, so I'm sorry. So yes, the question is, why is it not going to be adequate to say, I've got a syllabus, I've made a contract, I've explained what the scope of the class is and what the choices I'm making about why I've designed it this way, and won't that be enough to get me off the hook? Again, I think it would be nice if that were the case, but I have no real confidence that that's going to be the case. And we may discover that over time you develop a system in which you can develop a little more confidence that's the case. So for example, if students look at that syllabus and say, well, why didn't you have my favorite author on here? I'm really unhappy, I'm going to go complain to the human resource officers. And then you have developed a system in which the human resource officers say, we're just going to punt all this to the faculty. And so, yeah, we looked and we assessed your complaint and we are stamping it, not worried, and moving on, satisfied the requirement. Well, that'll be fine. But if instead the human resource officers look at the students and say, I'm very sympathetic to your concern, and I know the faculty had this very logical explanation they offered on the syllabus, but you know, as a very well employed human resource officer, I disagree with the faculty member about how their political science syllabus is constructed. There's no reason why you can't wind up then getting the professor in trouble for that. Likewise, then ultimately it goes up to the board of trustees, and there's no reason at all why you should imagine that the syllabus you designed will insulate you from the board of trustees looking at that syllabus and saying, I'm not sufficiently happy with the syllabus you designed. So, you know, so I think the law could be salvaged to some degree if you had, for example, a system in which precisely the faculty member had to create intellectually diverse syllabi, present them to a committee of other faculty or to a dean or a department chair, other members of the faculty, to get pre-approval so that I know then I've done what I'm supposed to do, I've checked my boxes, I'm going to be okay. But that's not the mechanism you have in place from the enforcement perspective. So I worry that you're going to get fired. That's my worry, and I worry that having a nicely designed syllabus is not going to be sufficient.
I think we have time for one more question.
Yeah. So the legislature has obviously imbued the board with a lot of authority.
Yeah.
But if the board isn't doing what the legislature anticipated it to do,
That's right.
what kind of is there anything that they can do with regard to the board? And relatedly, some boards aren't as open as others. Are there any kind of like requirements with regards to these proceedings that the board has to, you know, produce a record, provide some kind of notice to people?
Right. Right. So what kind of principal agent problems do we have with Board of Trustees? So you're a good legislature and you've done your best to try to design legislation that's going to try to rein in those crazy faculty, and you've entrusted the Board of Trustees to do your bidding. And what's to stop the Board of Trustees from not doing what the legislature wants from that regard? So there are no sort of elaborate procedural requirements relative to the board in terms of the board has to justify its decisions and offer a record explaining its decisions one way or another, which I actually think the worry there is it's going to lead to, it makes it easier to engage in arbitrary decisions, right? So if you don't have to explain yourself as to why you're doing it, it's easy for the board to just say, I didn't like that one, sorry. And you don't have to sort of go through something that looks like notice in common or something to help explain it. I think if you find in practice that boards, for example, just go back to the way boards have traditionally done it, is we're just going to rubber stamp these things, which is clearly not what the legislature wants you to be doing. You can imagine two kinds of political responses that are available to politicians at that point. One is you write more legislation and try to tie their hands more, make it more difficult for them to do that, so it becomes trickier and more challenging. I think that's always going to be a challenge. The easier and I think more consequential thing that can ultimately be done is boards for state universities are publicly appointed by politicians. And so you put in place members of the Board of Trustees who will do what the legislature wants in this regard. Now, maintaining the political will to do that over time, I think is going to be hard, right? That's one of the real challenges of politicians trying to rein in universities, is both you need board members who are capable of doing it, and you need a political will to actually sustaining that over time. So, right, so one reason why modern boards of regents for state universities tend to prefer the rubber stamp stuff is because the kind of people we put on boards of regents for state universities are people who really like the football program. They enjoyed their time as undergraduates. They're big boosters of the university. And so they care about lots of stuff about the university, but faculty syllabi is not among the things they care much about, right? And so, but you can solve that problem, right? And so if instead you appoint Christopher Rufo to be on your board of trustees, for example, who is an activist at Manhattan Institute and is now serving on the board of regents for New College in Florida and is a close advisor to Ron DeSantis in a lot of his education reforms, Rufo cares and pays attention and will totally be an activist board member for you. And so that's the principal agent problem for if you're a politician and you're trying to get the faculty to behave better. What do you do? What kinds of carrots and sticks do you have? Well, now you can get these directives, which they've tried to do to the board of trustees. The next step is you put in place better boards of trustees. And then if you really are going for it, you get the board of trustees to put in presidents and deans who are more in keeping with what you want as well. So, you know, it's tricky to get universities to bend to your will if you are a politician, but it can be done. But it takes some real effort. And this is at best probably first steps.
Okay. An article based on the lecture and expanding on it will appear in the Indiana Law Journal at some point. It's submitted, edited, subject by 2 L's and all of that. So, and also Professor Whittington has graciously agreed to be available for a small group session, just a general open discussion at 4:30. We asked people to sign up for that, and there's still probably a little bit of space if you're interested in coming to that and just engaging informally. That'll be at 4:30 in room 335 in the faculty conference room. So with that, please join me in welcoming.
Thank you very much.